Welcome to Young Legal Minds. In my previous presentation on certainty of intention, I covered what certainty of intention is. I also covered how it can be created, so through self-declaration or through appointment, mainly in the domestic context. I also mentioned what the requirements were for a gift with reference to the case of Rikka, and I said that just because the gift failed, so if those requirements are not met, the court are not willing to impose a trust. The court are not going to impose a trust to rectify the fact that the gift had failed. And I said that with reference to the case of Jones and Locke. So if you are unsure about the law regarding that area, I highly recommend you go and watch that presentation. But in this presentation, I'm still covering certainty of intention, but in the commercial context. So how trust can arise in the commercial context, or what through Todd and Wilson refer to as financial distress trusts. Now, there are two ways a trust can arise in the commercial context. There are probably more, but for the purposes of this presentation, you only need to be concerned with these two. A trust can arise in a Rikka Food type of situation. Essentially, a trust will arise to protect the creditors, who are usually customers, against the consequence of losing goods in which they have paid for upon the bankruptcy or insolvency of the company in which they have purchased from. A trust can also arise in a quis-close type situation. That's another case, Barclays Bank Investment in quis-close. So essentially, what happens in this situation is a trust arises to protect the lender. Those who lend money, they want to ensure that they are protected from the insolvency of the company that they lend to. So a quis-close trust arises where the purpose in which the money was lent fails. But I'm going to come on to all of that anyway. So far, that's just a very brief introduction to commercial trust. It's a very brief description on how they arise. I'm going to go into more detail now. So in the case of Rikka Food, there was a company which carried out a business in which customers would pay for goods in advance and the company would then deliver those goods. A number of customers paid for these goods, but the company couldn't meet all of the orders. They started to realize that they couldn't meet all of the orders they were receiving. And they also feared that they would go into liquidation. And just before they did go into liquidation, they were advised by their accountants to open a customer's trust deposit account in which they would put the money in specifically for the customers, so that if anything was to happen to this company, if they were to go into liquidation, they could easily refund the customers. Now, the company accepted the advice to a degree. They kind of half-heartedly accepted it. They didn't open the customer's trust deposit account, but they did put the money into a customer's dormant deposit account. Now, the bank, this is crucial that you know this, the bank was aware that the money was being held for the customers, that this account had been opened for them. So they had notice. Now, they didn't know that the trust had arisen, but they were aware of the facts which gave rise to a trust, and that's important. It's important that you know that. So the company did go into liquidation, and the court essentially held that the money was being held on trust for the customers. The customers were beneficiaries over the money they had, over the money in which they had given to this company for the goods that they never received. Now, because the bank had notice, they could not seize the money when the company went into liquidation. They were essentially not a bona fide purchaser for value without notice, because they had notice. They did not know there was a trust, but they were aware of the facts that gave rise to one, and that was sufficient. The customers didn't know that this money was being held on trust for them, but they didn't need to know. It wasn't important. They didn't need to have notice. It doesn't matter whether they know or do not know. The bank knew, they had notice, they couldn't seize the money. And Lord Justice McGarry made some pretty useful comments for us. He said, "I feel no doubt that the intention was that there should be a trust." He also said that, as a general rule, if you send money to a company for goods which are not yet delivered, you are merely a creditor unless a trust is created. That bit's really important. If you send money to a company for goods which are not yet delivered, you are merely a creditor unless a trust is created. So the only way you are truly protected is if a trust is created and you are beneficiary under the trust. He also said that the purpose of what was done was to ensure that the monies remained in the beneficial ownership of the customers, and a trust is the obvious means of achieving this. So that's the case of Rikka Food. Now I shall move on to how a trust can arise in a quiz-close type of situation. In the case of Barclays Bank investment and quiz close, a loan was made to a company on the mutually agreed condition, and it's important that you understand that it was a mutually agreed condition, that the loan would be used specifically and solely to pay the company's shareholders. So the loan was made to the company, and the company then paid the loan into a separate account, opened specifically for that mutually agreed purpose. The purpose failed. You don't really need to know why, you just need to know that the purpose failed, and the company then went into liquidation. The bank wanted to seize the money that had been lent to the company, and they put forward the argument that they were a bona fide purchaser for value without notice. The House of Lords held that the money belonged to the lender. Why did it belong to the lender? Because it was a purpose trust. There was a mutually agreed specific purpose, and that purpose had failed. The money was not at the borrower's free disposal and was not part of their general assets, so a trust had arisen for the benefit of the lender. The lender was a beneficiary over the money lent to the company. Lord Wilberforce said some stuff which we should be aware of. He said, when the purpose has been carried out, i.e. the debt paid, the lender has his remedy against the borrower in debt. If the primary purpose cannot be carried out, the question arises if a secondary purpose, i.e. repayment to the lender, has been agreed, expressly or by implication. If it has, the remedies of equity may be invoked to give effect to it. If it has not, and the money is intended to fall within the general fund of the debtor's assets, then there is the appropriate remedy for recovery of a loan. He also said that the arrangements of this character for the payment of a person's creditors by a third person gives rise to a relationship of a fiduciary character or trust in favour as a primary trust of the creditors, and secondarily, if the primary trust fails, of the third person. I highly recommend you give the case of Barclays Bank investment and quiz close a read. It's only 16 pages long. It may sound like a lot to some people, but it really isn't. And if you really do give it a good read, you will gain a lot of knowledge from it. It's really useful to know the insides and outs of that case. It will help you a lot. So Lord Wilberforce was essentially of the view that there are two trusts. There is a primary and a secondary trust. If the primary purpose works, the lender is merely an unsecured creditor. If it doesn't work, then the lender retains a beneficial ownership in the money, and that will be the secondary trust. Lord Millett in Twin Sector and Yardley was of the view that a resulting trust arose for the benefit of the lender as soon as the loan was made. Now, Lord Millett, that quote was only obiter. Generally, we go with Lord Wilberforce's view that there is a primary and a secondary trust, and that the secondary trust only comes into play if the primary trust fails. But it's useful to know the different views, and Lord Millett in Twin Sector and Yardley was of the view that as soon as the money is loaned, there is essentially the secondary trust kicks in as soon as it's made. So the ratio of this case is that where a lender lends money to a borrower for a specific mutually agreed purpose, and that money is not at the free disposal of the borrower, that money will become subject to a trust for the benefit of the lender if the original purpose cannot be achieved. Regarding the point of the bank having notice, Lord Wilberforce said that a mere request to put the money into a separate account is not sufficient to constitute notice. But on July 15, 1964, the bank, when it received the cheque, also received the covering letter of that date, which I've set out above. Previously, there had been the telephone conversation between Mr. Goldbart and Mr. Parker, to which I have also referred. From these, there is no doubt that the bank was told that the money had been provided on loan by a third person and was to be used only for the purpose of paying the dividend. So that's what Lord Wilberforce said regarding the bank having notice. He also expressed the view that a trust can exist alongside a contract, because that's essentially what a loan is. And if it could not exist alongside a contract, then the two systems, i.e. contract law and equity, would be discredited. Todd and Wilson sought to explain why a quizclosed trust exists. Now, whether this is why it was created is a different story, but they essentially believe that the purpose behind a quizclosed trust is to prevent those that do not hold legal title from benefiting from the property, or in this case, benefiting from the money loaned. And this view is in line with what Lord Millett said in the case of Twinsettra and Yardley, because he believed that the money is held on trust for the lender as soon as it is loaned, at least until it's applied for its purpose anyway. However, the question must be asked, is a separate account actually needed? What if the loan is paid into the company's general funds rather than into a separate account? Will a trust still arise? Well, it's probably best to have a separate account. It makes it easier for the court to find the trust. In the case of Anglo Corporation and Peacock AG, a loan was paid into the company's general funds and the court didn't find it there was a trust. So it's probably best that there is one, that there is a separate account. Although it must be mentioned that there were other factors in that case that led to the court finding that the trust didn't exist. The recipient in that case, so the borrower, didn't actually understand that it was to be used for the specific purpose. So there was the absence of a mutual agreement, because the borrower didn't understand that it was only being given for a certain purpose. But it is still generally accepted that the trust is harder to establish in the absence of a separate account. Lord Justice Watkins, in the case of Re Clowes No. 2, said that a separate account is an indicator of a trust, and that the absence of one normally negates a trust. However, in the case of Re EVTR, it was confirmed that as long as there is a mutually agreed specific purpose, and the important bit is that the purpose is agreed on by both parties, then it doesn't matter if the loan is paid into the company's general funds rather than into a separate account. Likewise, Lord Justice Evans Loam, in the case of Cooper and Powerhouse, said that as long as the money is not at the free disposal of the borrower, then it doesn't matter if it's not paid into a separate account. This case also shows that part performance of the purpose is not enough. It was said that the final whistle should not be blown at half time.